corporate debt. If during this period the tribunal does decide to proceed with the arbitral proceeding, any award passed against OAT shall neither be fair, nor expeditious, nor economic, since any such awards cannot be equal. If this tribunal is satisfied, I should move on to the next issue before this court. This tribunal, much obliged, was the tribunal. It is humbly submitted that Blackfield, by filing Section 65 application, has clearly waived its right to continue the present arbitration. I shall base my submission on two grounds. First, that under the NCLT application, Blackfield is trying to seek ownership of the HDBC under the garb of this application. And secondly, the principle of bliss alibi pendants, a common law principle, must prevent this arbitration from continuing. It is firstly submitted before this tribunal that Blackfield is trying to seek a relief which is already in effect. With that, I submit and I direct the tribunal's attention to Section 14(1)(b) of the Insolvency and Bankruptcy Code. Under this section, members of the tribunal, Section 14, talking about the moratorium, prohibits all of the following, namely, under subclause B, transferring, encumbering, alienating, or disposing of by the corporate debtors any of its assets or any legal right or beneficial interest therein. If I could have the tribunal's attention to page 8, para 32 of the Statement of Facts. Is the tribunal with me? Much obliged, members of the tribunal. In this, if we look at the second line of this paragraph, a Blackfield is seeking orders directing OAT not to transfer ownership of the HDBCs or create any third-party rights with respect to the HDBCs. Members of the tribunal, it is my humble and respectful submission before this court that OAT was already restrained from transferring, encumbering, alienating, or disposing of any of its assets. Blackfield, in the present case, is seeking this very relief from the said NCLT application. Therefore, it is my submission that Blackfield is simply trying to claim ownership of the HDBC under the garb of this NCLT application. Blackfield realized that NCLT does have exclusive jurisdiction over applications and proceedings by or against the corporate debtor. Therefore, Blackfield's actions clearly indicate that it has chosen to apply before the NCLT as no other forum has the jurisdiction to entertain or dispose of any such application. I sense a concern, Mr. Arbitrator.
But applying for interim measures is not contradicting an arbitration agreement, does it?
Mr. Arbitrator, to that effect, I submit that under this application, Blackfield is trying to seek a relief which is already in place. Although they have applied under the NCLT application, they have waived their right as the doctrine of waiver in the the test laid down in the doctrine of waiver do mean, as the legal remedies under both are the same. Does that satisfy the tribunal's concern? Much obliged, Mr. Arbitrator. Secondly, the principle of bliss alibi pendants applies to the present. This principle is extremely important for us to consider, as there is a possibility that when two courts hear the same dispute, they might reach an inconsistent decision. The NCLT has passed a mere interim order. It has started hearing the application of Blackfield, which is bliss pendant. Due to this, honorable members of the tribunal, this tribunal must apply the principle of comity of courts and recognize this waiver by Blackfield. I sense a concern.
Just one query. Can NCLT grant the final award as the arbitrator can with regard to the claim of Blackfield? Because the claim is with regard to damages. Now, does the NCLT have the jurisdiction to award damages?
Members of the tribunal, it is my submission. As the substantive claim arise out of the insolvency proceeding of the corporate debtor, NCLT as a forum has the jurisdiction to adjudicate on those particular contractual disputes which arise out of the CIRP process of the corporate debtor. And therefore, Blackfield has realized that this jurisdiction is available to the NCLT and has therefore tried to seek ownership of the assets that is the HDB. Does that satisfy the tribunal's concern? Much obliged. If this tribunal does not have any questions on issue 4, yes, Madam Arbitrator.
So under the SIAC rules, Rule 30.3 says a request for interim relief made by a party to a judicial authority prior to the constitution of the tribunal or in exceptional circumstances thereafter is not incompatible with these rules. So it is not incompatible for a party to seek interim relief before another judicial authority, even though they may have filed arbitration proceedings before the SIAC.
Madam Arbitrator, I have your concern. I do concede that this rule does apply to the present proceeding. However, it is my submission that by making this application, they have completely waived their right, and the tests under doctrine of waiver do apply to them, as the relief sought in the NCLT application and the arbitral proceedings are the same. They are trying to seek ownership of the HDBCs. If I could just provide another view to this very issue for the members of the tribunal. And looking at the corporate insolvency resolution process in India, there are 3 outcomes to this resolution process. Firstly, can be either the withdrawal of the CIRP. Secondly, it can be the successful resolution of the CIRP process, the corporate debtor and its revival. And lastly, under liquidation. Members of the tribunal, it is my submission that by claiming ownership of these HDBCs, Blackfield is trying to secure their assets under which will be subject to the CIRP asset pool. And if the company of OAD does undergo liquidation, they will not be able to seek any recovery from us. Further, even if OAD does become a successful resolution, Blackfield won't, because of the clean state principle, won't be able to seek any recovery. And therefore, by this NCLT application, they have tried to seek ownership to secure their assets, that is the HDBCs. Does that satisfy the tribunal's concern? Yes, Mr. Arbitrator.
But what was asked was not ownership, but simply to not transfer ownership and not to create third-party rights. These are interim measures. They're not the same as what you would ask at the end of an arbitration.
Yes, Mr. Arbitrator, I harbor your concern. However, it is my submission that by claiming these reliefs under this NCLT application, Blackfield has tried to seek ownership of the HDBCs and therefore tried to recover their HDBCs from this present, from OAD.
But he didn't ask for a declaration of ownership. He said, don't transfer ownership as an interim measure because we are claiming ownership. That's different from claiming ownership from the company law tribunal.
Mr. Arbitrator, to that I submit that if I could just have the tribunal's attention to para 30, page 8 of the fact sheet. Now, if I can just take this tribunal through this para. Immediately, Blackfield filed an application under section 65 of the IBC before the NCLT Mumbai, seeking orders directing OAD not to transfer ownership of the HDBCs or create any third-party rights with respect to the HDBCs. Blackfield alleged that it had handed over the possession of the HDBCs under the seal purchase contract and commenced arbitration to SEAT to recover the balance purchase consideration and other damages from OAD. Now coming to the operative part of this paragraph, members of the tribunal, Blackfield stated that as the HDBCs were the subject matter of this arbitration, they ought not be reckoned as assets of OAD. By this very line, we can assume that Blackfield is in fact trying to seek ownership of these HDBCs and trying to, Mr. Arbitrator, sense of concerns?
Trying to seek ownership from company law tribunal.
Mr. Arbitrator, to that I submit that Blackfield is trying to seek a relief that was already in place by this very moratorium. Under section 14(1)(b) of the IBC, Blackfield, OAD was already restrained from transferring, encumbering, alienating or disposing of any of its assets. Blackfield has sought the same recovery from the NCLT application from the NCLT bench of Mumbai. And therefore, it is my submission that Blackfield has completely waived its right to this present arbitration. If there are no further questions on issue 4, I shall move on to the last question before this tribunal. Much obliged, members of the tribunal. The last issue before the tribunal is the question of material breach by Blackfield, their invalid termination of the SPC, and the alleged payments of damages to Blackfield. For this, I shall be making a three-pronged submission. Firstly, OAD did not materially breach the SPC, and Blackfield is the one who breached the SPC. Blackfield invalidly terminated the contract, and OAD is in fact entitled to damages under the SPC. Firstly, at the outset, it is submitted, honorable members of the tribunal, that OAD has not breached any term of the SPC, as it is protected by Article 18 governing the under the SPC, which recognizes force majeure events. Now, in India, COVID-19 has been recognized as a force majeure event. COVID-19 and its impact was an unpredictable event which occurred and impacted commercial contracts. Even Article 18(1) of the SPC, if I could have the tribunal's attention to page 11. Is the tribunal with me? Much obliged, members of the tribunal. Article 18(1) of the SPC recognizes epidemic or pandemic as a force majeure event, which is exactly the case here, members of the tribunal. COVID-19 caused a lot of financial stress to OAD, which pushed OAD into insolvency. Further, members of the tribunal, as my learned friend pointed out, regarding AAI and OAD regarding AAI and OAD under Article 18, AAI is also a party that did cause additional delays, which pushed the completion of the SPC. Contractors were not quickly approved by AAI. This was another unpredicted event, which was beyond OAD's control. All the events that occurred made the performance of the contract, hampered the performance of the contract, that is to say. Moreover, it is submitted that Blackfield is the one who has actually breached the SPC under Article 1, as delivery of the HDBCs was inconsistent with the clauses under Article 1. If I can have the tribunal's attention to Article 1 of the SPC, page 10. If the tribunal is with me. Article 1, talking about definitions, goods. 4 units of horizontal diverter baggage conveyors in conformity with technical specifications set out. Members of the tribunal, this is what I would like to bring to your attention. The delivery of the HDBCs was inconsistent with this very term in the SPC. Blackfield supplied defective HDBCs, which resulted in an additional delay of 2 months in the installation process in the arrival wall of the MIA. This caused severe financial loss to OAD, and amidst the financial strain it was already in. And even AAI is the one who imposed penalty on OAD for this delay. Secondly, it is my humble submission before this tribunal that Blackfield did not validly terminate the SPC by following the due procedure laid down for termination under the SPC. In the instant case, OAD has not breached any provision of the contract and has taken the protection under the necessary term which was agreed to between both the parties, that is force majeure event under Article 18. Members of the tribunal, it is lastly submitted that these actions of Blackfield make them liable to compensate OAD by way of damages. This, in fact, is a clear breach under Article 1 of the SPC. OAD has not only suffered extreme financial loss due to being beloved with the HDBCs, but also due to penalties imposed by AAI on account of such a delay. Therefore, it is prayed before the tribunal to direct OAD
pay damages on account of defects in manufacturing of the HDBCs and amounts of penalty imposed by NLI. I sense a concern.
If I'm not mistaken, the goods were ready to be delivered in January. Now, if they had been possible to deliver them in January, then the defects could have been corrected in time for the date of delivery 24 months later. If that is the case, the reason why they were late is because of the delay, maybe due to force majeure. But nonetheless, it's not necessarily their fault, because if anything had been according to plans, they would have been able to deliver on time.
So, arbitrator, I completely understand the concern. And like this tribunal has correctly recognized that OATs were delays on account of force majeure. However, it is submitted that all of our delays were properly referred to and communicated to CAFE. Whereas this particular delay or defect in the HDBCs was something that was beyond our control. They were supposed to look after the conform, they were supposed to take care that the HDBCs were in conformity with the specifications laid out in Annexure C, which is currently not provided to us in the statement of plans. Yes, Madam Arbitrator.
Can I refer also to Article 5 in terms that you were responsible at the point of receipts at the airport, the Mysore airport, to inspect goods, ensure that they were in conformity, and at that point, we would have it over to you.
Madam Arbitrator, could you please clarify your question? I don't understand.
Yeah, so under Article 5,
Yes.
it shall install over the HDBCs at the airport to it, but there is a right of inspection at that point that it over. So the question is, at that point of handover, if the inspection was made, but there was no issue identified at the point of receipt, was there not a waiver? And
The waiver to
a waiver of the right of inspection and a waiver to raise further issues under.
If I could ask a further clarification from Madam Arbitrator, under what act, under what legislation would this waiver be?
No, in terms of the receipt of the goods, so this is receipts at the airport, and there was a right of inspection at that point, but there was no issue identified at the point of receipt. This issue of conformity was much later. So, under this particular article, this does not place some obligation responsibility on the respondent for this delay.
Madam Arbitrator, with that I submit that inspection of the HDBCs that was allegedly supposed to be conducted by Blackfield is silent on the statement of facts. However, when the issue of installation did come up, the issue of installation was supposed to come up at the Mysore International Airport. Only when the HDBCs were installed did we realize that they were not in conformity with the specification provided under the Annexure C of the SPC. And at that point, did we raise the concern of their violation under the SPC and their non-conformity with the particular dimensions and design of the HDBCs. Are there any other concerns from the tribunal? Then I rest my case. I thank this tribunal for very kindly and patiently.
The council seeks the tribunal's permission to start the rebuttals. Much obliged. I have 5 rebuttals to make. The first being that the Respondents' Council mentioned that the given proceeding has to be barred by Section 14, since it mentions that all proceedings which have been instituted before and after a moratorium has to be barred in order to enable the corporate debtor to maximize their assets and reorganize the same. However, as has been submitted by the Claimants Council, it is observed that the code only has a territorial application and it does not extend to foreign city arbitration. Additionally, there was another claim that was made by the Respondent Council with respect to the enforceability of the award in India. It is our contention that a mere breach of an Indian law is not a ground to prevent the enforceability of an award in India. And the same has been held in the Supreme Court cases of Sri Lal Mahel versus Progetto, which draws its principle from a pre-arbitration conciliation act case of Renu Sagar versus General Electric. But that case brings the amendment to the Arbitration Conciliation Act and talks about the fundamental policy ground which has been mentioned by the Respondents' Council, as a result of which the moratorium is inapplicable to the given arbitral proceeding. The second rebuttal being, a claim was made that the claimant sought the ownership of the goods. However, it is our contention that we sought the prevention of the transfer of ownership to the third-party rights and the protection of the goods, because the same is the only security that we have. It is our submission that the claim that we seek for the payment of the balance consideration is contingent on the HDBC not being transferred or sold to any third-party right. If only the same exists, can we submit the same as a claim eventually before NCLT Mumbai and seek the payment of the balance consideration, as a result of which we have not seek the ownership of HDBCs. Moving on to the fact that the Respondents' Council mentioned that the clean slate principle is not applicable in the present case, it is our submission that the clean slate principle only comes into place in the second situation that was submitted by the Claimants' Council, in which situation it is observed the moratorium is not in place or a CIRP is not in place. It is our observation that it flows from the first fact that if an interim relief has been granted to us, our claim has been witnessed to be a disputed claim. And under Section 29, Clause 2 of the Code, it is the obligation of the resolution professional to inform a resolution applicant of any pending disputes or pending claims. So eventually, even if the entire restructuring happens, if you seek the payment of the balance consideration from the resolution applicant, since they've already been informed of the disputed claim, as a result of which our case falls within the clean slate principle. Additionally, the Respondents' Council mentioned that they are granted an exemption under the force majeure clause. However, it is our submission that since the contract was negotiated in 2021, it was done in a period in which the entirety of the world had undergone and had gone through the impact of COVID-19. Hence, the same was unforeseeable. And additionally, as has been submitted, in order to seek an exemption under a force majeure clause, may I please submit these reporters? Much obliged. It is observed that the parties will be directly impacted by the force majeure event that they're seeking. The Respondents' Council haven't clarified under which ground a delay in approval of contractors falls within, and it is, as has been submitted, it is the collated fact that the delay in approval of contractors as well as the COVID-19 outbreak led to a situation in which they face substantial hurdles. As a result, the force majeure clause does not grant them an exemption in the present case. Additionally, they mentioned that there were variations in the HDBCs which led to further delay, and as a result of which they seek a reputational, they have faced a reputational loss seeking damages. However, it is our submission, and as has been rightly pointed out by the arbitral tribunal, the given case falls within the doctrine of temporary disconformity. For the tribunal's satisfaction, it is observed that in the case of Todman Brown versus Melvin Ryan, was in paragraph 87. Just dwelling into the facts of the case briefly, it is observed that the house was to be constructed, but during the performance, midway through the performance, the design was not in conformity. But subsequently, the contract was completed, the house was designed according to the design that was mentioned in the contract within a stipulated time. In the present case, it is observed that even if the modification and the variations were observed, it only took us 2 months with 3 shipments coming all the way from Germany. And if the contract was complied with on behalf of the respondent, the same would have been completed within the completion date. And it is observed that mere imperfection till the time completion of the performance has not been observed, does not amount to a breach of contract. As a result of which, the given case does not amount to a breach of the SPC on behalf of the claimants. And with this, I come to a conclusion of my reference. Much obliged.
Members of the tribunal, may proceed with my survey, John. I would not like to take much of this tribunal's time. I should just make 2 broad submissions. Firstly, that we do concede that the IBC does not have extraterritorial effect. And that is why we plead before this tribunal to consider this moratorium. Because even if this IBC does not have extraterritorial effect, IBC does bind OAD, which is our client, to the arbitration, to the insolvency proceeding. OAD, being an Indian incorporated company, is bound to follow the code of the IBC, and therefore the tribunal must consider the application of the moratorium in this present arbitration. Secondly, if I can have the tribunal's attention to page 16 of the fact sheet, Annexure B extracts from OAD's statement of defense and counterclaim. If the tribunal is with me, I would like to direct the tribunal's attention to para 5. In addition to the above, Blackfield has also submitted the jurisdiction of NCLT by filing an application before NCLT seeking such reliefs which may necessarily require the NCLT to determine Blackfield's claims, which are duplicated here. By virtue of this submission to the jurisdiction of the NCLT, Blackfield has rightly submitted to the jurisdiction of NCLT to determine these claims, and NCLT is the appropriate forum for determination of these claims. Accordingly, this tribunal ought not to exercise jurisdiction over Blackfield's claims. Blackfield is agitating the same claim repeatedly, which should not be allowed. I believe that this effectively rebuts the argument about ownership made by my learned friend. I rest my case here. I thank this tribunal for a very patient hearing.
So I would like to thank both the kings for very impressive arguments and presented before us five judge bench. Well, the only thing I can say is that you were very well versed in facts. You answered our questions exceedingly well. So far as the law is concerned, we would have expected a little more of applicability of the law as a contract says Indian law is applicable. Little more reference to the judgments which you are relying upon and how it's applicable to the facts of the case. So that you must bear in mind, that devote a little bit of time to that as well. And you have addressed the issues, and I would like to congratulate both the teams.
I was very impressed. Thank you very much for a very clear and excellent presentation. Thank you.
I think both teams were excellent. And I echo Justice Chadha's view that the only missing point was really, I think, that you could have done a bit more collaborating with authorities. Like I was waiting and, trying to nudge you also to get answers that you say there is a judgment on this point with that. And which I'm sure is part of the memorial, but was not part of the arguments, which would have been more solid in the case. But I think presentation-wise, all four of you really exceeded. And if I can compare with last year, which I also judged the group, the benchmark is really gone up. So many, many congratulations. So much confidence, despite the sitting judge, sitting arbitrator, all representations. I did not see any one of you fumble or waver at any of the questions asked. And I think that speaks a lot of the quality of the students. And who are going to be the next future judges and lawyers. So thank you. It was a pleasure being part of the tribunal judging you all, and wish you all the very best.
Yeah, I can't add much to that. I just would say I agree, and it's a pleasure to hear both of you and both sides. And I think that I was also very impressed with the demeanor and the respect shown to one another and to the tribunal, and also your grasp of the facts.
I think both teams have worked really hard, and that really shows. So, firstly, all the very best to you. And I think I would just echo Justice Chandler's view as well, that there was a lot of scope given the problem, sort of delve into some quite applicable legal principles, which I think next time it's just something to keep in mind. All the best.